கரெக்ட் ஆயிடுச்சு. அது மாற்றி விட்டுருங்க. 1 minute சார். ப்ரெசன்டேஷன் மாற்றி விட்டுருங்க.
Very good evening to all of you, and very happy, healthy, and prosperous new year wishes to Ronanda. I am really delighted and very much honored by the introduction given by the member. Actually, I attended last conference 1 year back, only as a delegate, and I am sitting along with you. But after my retirement, my beloved and respectable principal has promoted me as a resource person. So that I am standing before you. Mr. Srinivasan is a perfect personality in conducting such huge conferences and other things. He is helped with a team of professors, and I have thanked all the team members for the successful conduction of this conference effectively throughout the day. Actually, last session was very much interesting one. It is about the feature aspect of consumer protection, and I am going to deal with the past history. And many judgments will be familiar to you all. In spite of that, kindly bear with me. The title itself says judicial evaluation. Judicial evaluation is nothing but the common interpretation of law given by the judgments and judges. The expansion of meaning, definitions, and various principles by the court. The step-by-step progress towards reaching the object of consumer protection. So, jurisprudential evaluation is nothing but what the court was all along dealing with Consumer Protection Act and other things, and the judgments may be familiar to you. I will assure whether this session will be informative, educative or not, but I assure you that this session will be most interesting one, because you are all going to participate, and this is not one-way traffic. I am not going to communicate. You are entitled to communicate. You are free to ask any question, free to comment, and I request everyone to be relaxed. First, actually, I will rush through the back history. Consumerism is not a new one as far as India is concerned. Even in the ancient days, Manuvedi and Arthasastra Kaurya deal with the same consumer rights in different way, different method. Actually, during the Manuvedi period, that is before kingdom, in the period of kingdom, they have severely punished every businessman, severely punished with a punishment of mutilation. And during the 300 and 400 AD, that is during Chandragupta Maurya, Arthasastra was written, and in which it has been noted that one trader of officer maintaining traders and the other standard was appointed. So this is the basic history during kingdom. Subsequently, during the British period, consumer is mainly to depend and work out his redressal only through common law, such as torts, Contract Act, and fiduciary laws like Sale of Goods Act, Agricultural Protection and Marketing Act, Drugs Act, etc. But the basic principle behind all these acts is Kevai Tamka. Kevai Tamka means the buyer must aware what he is buying, and he must be vigilant while buying a product or hiring the service. This basic principle has been now replaced by Kevai Tamka nowadays. That is, now the seller must be aware. He must be vigilant in telling the true status of the thing he is going to sell. Next. After independence, many acts have been enacted, that is Drug Control Act, Essential Commodities Act, Prevention of Food Adulteration Act, etc., including Consumer Protection Act. Actually, the next slide. He is the father of consumerism. Ralph Nader. Yes. How many of you can't understand Tamil? Because only 4 or 5, 5 or 6, 7. Okay, no problem. Because it will be easy for me if the session is bilingual. Unexpectedly and unwillingly, I am switch over to my mother tongue. Bear with me, that also. So he is one of the exemplary activists, and he raised the first consumer rights in the United Nations. Actually, he warned the American people about the health hazards of red dyes used as food coloring and nitrates used as preservative in cartons. So it is the first voice raised on behalf of consumer. Then only UNO took the issue and they formulated certain principles. Is it not? Because of paucity of time, I skip over. These are the principles. Though the above guidelines and principles were not the force of any law and rule, however, on the basis of the same, Consumer Protection Act has been enacted by the Indian government in the year 1986. Next. So the Consumer Protection was enacted finally in the year 1986 and it has been amended in the year 1991, 93 and 2002. In spite of such amendments, the Consumer Act was not as effective as expected by the consumers. So it needs further evaluation and further modification, further amendment and other things. So the matter was, at the time, the matter was taken note of by the Honorable Apex Court in the Supreme Court of India versus State of UP versus UP Consumer Protection Bar Association. In the judgment, the Supreme Court appointed Justice Ajit Pasai, a judge of the Supreme Court, to look into the affairs of consumer commissions throughout the nation, district level and state level, national level, and to ascertain about the position of vacancy, deficiency in infrastructure, administrative powers, the service condition and other things, etc., etc. And the Government Commission finally, after extensive visit throughout the India, found many discrepancies, deficiency, vacancies, and everything, and he submitted a report. On the basis of the report, a detailed judgments were passed by the Supreme Court, directing the central government to frame rule and also directed the National Commission to frame regulations effective implementation of Consumer Protection Act. Finally, what we are having is the present Act 2019, Consumer Protection Act 2019. The Act came into force on 20th July 2020. Variety of new features have been included. Addition of e-commerce transaction, establishment of Central Consumer Protection Authority, product liability and unfair contracts, penalization in case of misleading advertisement, change in pecuniary jurisdiction, provisions for alternate dispute resolution, etc., etc. So this is the new features embodied in the Consumer Protection Act. The salient features of both acts is what I say. Actually, both acts deal with effective implementation of consumer protection, but the salient feature is it is a beneficial legislation. Actually, it is one-sided one. The main aim of the act is just to benefit the consumer. The main object of the act is that redress the consumer grievances effectively and within a time frame. So it is a beneficial legislation, and the nominal fees are imposed for filing cases. The exclusion of Civil Procedure Code and the Indian Evidence Act from the purview of the Act, and the advocate is not at all necessary. Judicial and non-judicial presiding officers and time of adjudication are the benefits given under the both acts. When such benefits have been given to a consumer, what will happen? Necessarily, the other side, the traders and the business people won't like the Consumer Protection Act and they questioned the validity of the act itself before the Supreme Court in state of Karnataka versus Viswa Bharati Cows Building and Cooperative Societies and other. The question raised before the Supreme Court is the legislature did not have the competency to enact such law. For that, they have submitted many arguments, and they are quite interesting also. The first argument is the parliament is not empowered to establish hierarchy of courts like the district forum, state commission, and national commission, parallel to the hierarchy of the district court, high court, and Supreme Court. This is the first. Such hierarchy of consumer courts established under law would result in conflict of decision with the hierarchy of court. When a same matter is pending before a civil court and consumer court, there is every chance to pass different judgments. It is inevitable. And they have also questioned the constitutional validity and other things, but overriding all the objections, the Supreme Court that the legislature had got the competency to enact the law, and it is for the benefit of certain sector of public, and it is a beneficial legislation. Okay, next. These are all some basic history, and I have rushed through. Now coming to the judgments. Actually, the main issue, whenever a complaint is filed, the main issue is whether it is barred by limitation or not, and it is the duty of the concerned district president, state president to look into the matter. While admitting a claim, it is the duty of the concerned district commission and the state commission whether the complaint is barred by limitation or not. Once they satisfy that the complaint is not barred, then only they can take the case on file. As far as the law is concerned, in Yanamani Anusuya and Parvitini, Amarendra Chaudhary and others, 2007-10 Supreme Court cases, Section 3 of the Limitation Act was dealt, in which case stated that it is the duty of the concerned judge to decide the limitation whether it is raised by other side or not. Even if the point of limitation was not raised by other side, it is the duty of the concerned judicial officers to look into the limitation. But once you have taken the case on file, then the question will arise whether the cause of action is within the period of limitation is not is a question of fact and law. Next. In State Bank of India versus BS Agricultural Industries in 2009, the court, when dealing with banks' duty, found the cause of action arose in the year 1994, June 1994, but the complaint was filed in the year May 1997, so it is clearly barred by limitations. They have dealt with the case detail and finally found when the cause of action alleged is beyond the limitation point, no concession can be given to complainant and it is liable to be dismissed. So it is strictly adhered to law in 2009. Second one is next. Kandipalla Raghavaya versus National Insurance Company. In this case, a fire broke out in the premises of the institute on 23 March 1988, and the appellant filed case only in the year November 1992. It is his allegation in the complaint that his bank was taking care of the insurance claim and they had contracted the insurance so that he did not get any insurance from the insurance company and other thing, and there is no defect on his part, and they request that there is no bar of limitation and to break the case within the time of limitation. But the Supreme Court did not accept the convention on the facts of the allegation mentioned in the complaint. when the fire accident took place sometime before 5 years, the lethargy of the complainant in approaching the court after 5 years and blaming contraband, a bag is unacceptable, and they did not condone the delay. Subsequently, in Anshu Agarwal versus New Okra Industrial Development Authority, the Supreme Court took a different view. Actually, it is a beneficial legislation favoring consumer, but opposite party playing any delay tactics and other thing, it has to be viewed very seriously. In this case, they have clearly mentioned it is also opposite to observe that when deciding an application filed in such cases for continuation of delay, the court has to keep in mind that the special period of limitation has been prescribed under the Consumer Protection Act for filing appeals and the revisions in consumer matters, and the object of expeditious adjudication of the consumer dispute will get defeated if this court was to entertain highly blatant petitions such like. So the view of the Supreme Court has been changed in favor of the consumer. Actually, originally they have took both consumer as well as the businessman in the same cadre, but in this case, they differentiate the consumer are entitled to get a favorable order when unnecessary delay has been shown by the other side. So the law has to be strictly adhered in favor of the consumer complaint. First, both were equally treated by the Supreme Court, but in this case, when delay is concerned, the law must be favor the consumer complaint, and the opposite party is liable for the delay. He is liable for the delay, and he should be properly dealt with. In the other case, Supreme Court of India in National Insurance Company Limited versus Hindustan Safety Glass Works Limited. In this case, the fire was broken up some 3 years back, but after 3 years, the consumer complaint is filed. But the correspondence shows the delay was mainly caused by the insurance company. The delay was caused mainly insurance company. They have appointed surveyor. In spite of appointment surveyor, the claim was not satisfied. So, at this context, the Supreme Court found the reason for the delay is only the business, the opposite party, the service provider. When the reason is because of the service providers, then the delay is to be condoned by the consumer commissions. So this is the latest position, and we have to condone the delay whenever a valid reason has been submitted, either in the print or by way of special a separate petition. We have to consider liberally thereto in favor of the consumer. In the other case, Viva Bakshi Kogale and another versus Gopal Sleep and Construction and other. In this case, the Supreme Court found National Commission even did not condone a marginal delays in favor of the consumers. In favor of the consumer, not in favor of the opposite party or service providers. So there is the delay is marginal one, and the delay is in favor of if the condonation of delay is in favor of the consumer, then the nominal delays are not to be taken into consideration. So the present position, the evaluation with regard to point of limitation is first they took both parties in the same cadre. Subsequently, they made some exception in favor of consumer, and finally they have felt marginal delays automatically to be allowed in favor of consumer. So this is the jurisprudential evaluation as far as limitation is concerned. Next, consumer.
Excuse me, sir.
Yes.
What should be considered as marginal delay?
Marginal delay, it is up to you. Actually, I will narrate after my session. I will tell you how to expand. Actually, Consumer Protection Act is not a small square. You can expand. That is, when you did not follow the Civil Procedure Code and Indian Evidence Act, sky is the limit of the judiciary. You are guarded only by the principle of natural justice and to your conscience. When you are consciously felt that the consumer complaint is bona fide one, don't hesitate to order in favor of complaint. Because I retired from service, I did not tell this. Actually, while in service also, I followed this principle because it was the message carried by me in the last conference. Mr. Ashok took a class and he gave some exercise in favor of, and you remember. So the message given by him, when all the officers are feeling that the consumer complaint is a bona fide one, no, don't hesitate to allow overcome the objection made by the opposite party. That is the basic principle. Okay, here we go. We cannot deviate from the basic law, the square of basic square we can read, but we can expand the square a little bit. Next, consumer. What is? Canara Bank versus United India Insurance Company. In this case, there is a tripartite agreement between agriculturist, bank, and insurance company. The agriculturists borrowed loan from the bank, and they have stored the materials agriculture produced in a godown. The godown caught fire, and all the materials were damaged in the fire. When a claim is made by the bank, when the claim is made by the farmers, it is the case of the insurance company that there is no privity of contract between the agriculturist and the godown. They have only they have entered into agreement of insurance only with the godown. Neither Canara Bank nor the agriculturists are not party. So we cannot honor any claim made by the agriculturists. Negatively the convention, the Supreme Court held the beneficiaries also come into the definition of consumer. So the consumer is not only by the act definition, it is enlarged and interpreted in a way favoring consumer by the apex court. Actually, this is the latest case. Even the same issue has been raised in Spring Meadows hospital case. Hospital also the same principle has been given, but it is only an expanded version of the above principle. So under the fold of consumer, the beneficiaries also will come and entitled to file consumer complaint. Recently, next. When a company can be a consumer under one law. Can a company and what act is not covered. The definition did not cover company. So in the 2019 Act, the company was also included. So an interesting question has been raised. When the old act did not explicitly mention about company, how a company can be filed under the old act? But that is Gossip Flux Matters Private Limited versus SP General. It is a contention only as per the 2019 Act, company has been incorporated as a consumer. So any complaint filed by a company subsequent to 2019 is maintainable, as it is not included in the 1986 Act. The company cannot be a consumer, but the Supreme Court overruled the objection and finally held, even though 1986 Act did not include company as a consumer, it impliedly on the principle of judicial interpretation, company is also entitled to file consumer complaint. So whether it is included in the earlier act or not is not a question. Well, it is a clarificatory in nature. The 2019 acts, they found some omission. They want to clarify, they want to expand the earlier definition. It didn't mean that earlier definition not covered insurance side. Next. So company can file a consumer complaint. Now the question is reversible. Can you execute a degree against a company? A consumer complaint is made against a company. How you can execute? Since there is no provision in either in the CPC or in the Consumer Act to execute a degree against company's directors, not company's directors or its partner and other thing. Or member, company member, partner, not partner, company member. Partnership Act, you can execute the degree against partner because all the partners are liable for the debts incurred by the partnership business. But the position of company is entirely different. The company director cannot personally liable for the company's act because a director at one time cannot be a director subsequently. So a personal execution cannot be made against directors. But in this context, I want to refer the judgment. Singer India Limited versus Chandan Mohan Chava and others. In this case, whenever a defense has been taken by the company director that they are not personally liable and no degree can be executed against him, it is the duty of the commission and the court to lift the corporate rate. Yes. Because sometimes who is the owner? He is the director. The one man conducted the company and other thing. If you lift the consumer, the corporate rate, then you can find out who is responsible for the company affairs and you can execute the order. So you keep it in mind while execution of any award against company. Can you lift the bail or not? You can work it out and pass appropriate order. I am actually rushing through because of paucity of time. If you want to elaborate discussion, we can discuss. Now, the famous case. Bar of Indian Lawyers through its president versus D.K. Gandhi. Hope you all know about the outcome of the judgment. In the judgment, it has been clearly held that advocates cannot be a service provider and they can be prosecuted under Consumer Protection Act. How many of you, we are all bound by the judgment, no doubt in it. But how many of you agree? How many of you know what are the points raised on behalf of the advocates? How the court held that advocates are not covered by the Consumer Protection Act? Can I go through the judgment? Yes? Agreed. You are not agreed. Master servant. There is no, in every case, there is no master and servant. When you hire an engineer to construct a house, is there any agreement as master and servant? Yes. But the logic is an important question of law pertaining to the legal profession as a whole that is fallen for consideration before this court. Whether a complaint alleging deficiency in service against advocates practicing legal profession would be maintainable under the Consumer Protection Act 1986 as being enacted in 2019. So it covers both services under 1986 and 2019. Accordingly, the return by the NCPS following unique attributes become clear. Advocates are generally perceived to be their clients' agents and owe fiduciary duties to the clients. There is no master and servant relationship. On the other hand, it is a principal and agent relationship. The first point, yes, advocates are present with all the traditional duties that agents owe to the principal. For advocates are not entitled to make concession or give any undertaking to the court without express instruction from the client. So they are bound by the instruction of the client. They cannot make any other submission against the wish or without knowledge of the clients. It is the solemn duty of an advocate not to transgress the authority conferred on him by his client. An advocate is bound to seek appropriate instruction from the client or his authorized agent before taking any action, and so on. But the point is, it is a judgment of two judges by the Supreme Court. In the above judgment, they question the validity of implicating doctors as well, and they refer the matter to larger bench for constitution of larger bench by the Chief Justice. They refer the matter because of they differ from the earlier version that professionals are not liable for mistake committed by the under Consumer Protection Act. They also concluded doctors will also come under the category of advocates. So it is their view that doctors cannot be prosecuted under Consumer Protection Act. It is a view expressed by the judges of the bench, and they referred whether doctors will come under the purview of Consumer Protection Act and other thing to a larger bench. But in Indian Medical Association versus BP Sartha, it is a 3-judge bench decision. 3 judges decided that though they are professional, they are not exempted from the purview of Consumer Protection Act, and if there is negligence or deficiency in service on their part, they are liable to be prosecuted under Consumer Protection Act. Because it is also an evaluation, either in the forward direction or sideways direction, not backward, sideways direction. So now the new thing is whether the doctor is coming under the purview of Consumer Protection Act is referred to larger bench. Next. Let us do they refused.
Yes, they refused.
Refused,
They don't want to interfere with them.
very good, very good. Then, so doctors will come under the
Yes. Settled.
So refused, sir. Very good. Thank you for enlightening me. Because I have already told I am not a scholar, and still I am one among you as a delegate. Thank you for enlightening me. So this is the very good view taken by the Supreme Court. Okay. Next thing is education. As far as education is concerned, in Bihar School Examination Board versus Race Prasad and the Supreme Court held when the examination board conducts an examination in discharge of its statutory function, it does not offer its service to any candidate, nor does a student who participate in the examination conducted by the board hire or avail of any service. So the Supreme Court clearly held education offered by Education Board is not a service and they will not come under the purview of Consumer Protection Act. But they also relied upon, in this case, they have also, they have also relied upon Lucknow Development Authority versus LK Gupta, Ghaziabad Development Authority versus Balbir Singh. So they clearly evaluated the law and said that the education will not come under the service, and the category of service, and they are not consumer protection.
It's before larger bench now. The education, that dispute is pending before the larger.
I will come with it. They hold, it is a bench decision and, okay. And subsequently, though there are two judgments of Lucknow Development Authority, M.K. Gupta, Ghaziabad Development Authority, Bhagat Singh, they distinguished what is statutory function and what is sovereign function and other thing. They distinguish what is tax and what is fees, everything, and hold even statutory authorities are also liable under Consumer Protection Act. They are also service provider. In spite of such specific decision from two earlier judgment, the Supreme Court in Haryana Urban Development Authority versus Sivika. Interestingly, I saw in small letters. You have to forget about the judgment. Yeah, but the thing is, in this judgment, they held Haryana Urban Development Authority is not a service provider and no consumer complaint can be made against them. Contrary to two earlier judgment, this judgment was prevailing for some time. The effect is next. As much as more than 25 cases has been disposed of relying upon the same judgment by the apex court. Not only that, damage was not only that. In the another case, Punjab urban planning. Okay. Yes. In Punjab Urban Planning and Development Authority versus Vidya Chatter, the Supreme Court appointed 3 judges, constituted 3 judges bench, and they have held that statutory authority will also come under the purview of Consumer Protection Act, and this is the present binding judgment of our Supreme Court. Next, we have to follow only this judgment. It has narrated and discussed all the area judgment. What is the statutory functions and what is the sovereign function. So, one of my member friend asked me whether giving patta, whether obtaining patta is a service offered by the officials. I held that this is not service, but it is the sovereign duty. But anyhow, the present scenario needs because another president, Mr. Sundar, told me, as per section 1(3) of the Act, only services exempted by the central government alone will not come under the purview of. So it is do evaluate. I already hold that issuing patta is a sovereign duty. It will not be a service to an individual. But this judgment, Punjab Urban Planning and Development Authority made various discussions with regard to what is statutory function, what is sovereign function, what is tax, what is fees, whether the service is benefit for entire public or it is a special service offered to an individual, and etc. etc. Kindly go through that view. Now I am no more judicial member. So it is open for you to decide as per the judgment. Next. Class action. Class of action. Actually, J.J. Merchant and Srinath Chaturvedi, Cinco Industries, I will dealt with some special cases, but if time permits, we will discuss class of action of consumer. This is one of the salient features included in Consumer Protection Act. Like in the Civil Procedure Code, Order 1, Rule 8 is there. You can file a suit in the representative capacity. You can represent numerous persons in single petition. Similarly, a provision is interpreted in the New Consumer as well as Old Consumer Act. If there is any omission in the Old Consumer Act, it is simply an omission, but includes the class of action. Bhopal case tragedy, earlierly, Mr. Senior Counsel Raja also brought to your attention. That is a class of action by Bhopal. After that, this class of action gained momentum, and a number of persons can jointly together file a consumer complaint before the Consumer Commission, and it is maintained. There is no necessity that all the consumers belong to same grievances and other thing, but they are having any common grievances. But because one consumer can claim 10,000, another consumer can claim 20,000, that is directly different. But they are having some same cause of action against the same service provider. So class of action is maintainable, and another judge, Anjum Kushain versus University Business Park, also held the class of action is varied. It is one of the salient feature of the Consumer Protection Act. So numerous consumer can file they can work out the grievances in single petition. It is one of the benefits given to the consumer. Section or next. Venkatachalam versus Ajit Kumar, 2012. Yes. In this case, an interesting question has been raised whether an agent can be permitted to argue and represent a case before the Consumer Commission on behalf of the Commissioner, on behalf of the consumer. Can an agent, power of attorney, can an agent represent before the? Yes.
But
Don't mistake. Yes.
Delhi High Court.
Yes.
Except advocates, nobody can.
Yes. It is the prevalent situation that an agent can be prosecuted the consumer complaint from filing till the end. But the thing is, the rule says the agent is permitted to present on behalf of consumer a complaint before the consumer court. Only the S2 rule says an agent can be permitted only to present a consumer complaint. But the Supreme Court went on to say that an agent is empowered not only to present, but he can argue before the Consumer Commission on behalf of his consumer, on behalf of any consumer, and they directed the National Commission to frame rules accordingly. So the rules have been subsequently framed, and an agent will appoint. Yes. Naturally, when he can begin the case, why can't he join middle? So it is natural. Next. Section 27. That is what action section 27. Now
72.
72.
Reverse.
In which you have given magistrate power
Yes.
to prosecute a defaulted service provider in summary way as if you are magistrate of first class. But when you act as a judicial first class magistrate, special notification is required from government as well as from the CTA. The power to act as magistrate is to be conferred. Then only you can act as magistrate. So the question is raised before, fortunately before the Madras High Court. So now without power conferred on you, how you can act as a judicial magistrate? You know the result. You can act. But how? because the National Commission already sent a communication to all the district commissions, state commissions that 27-2 has been clarified by the National Commission by a letter dated 27/5/2003. It was issued by the retired judge of the Supreme Court. So this was clarified by this judgment that you need not get any special powers from the government or from any other authority to deal with consumer service provider under section 27 or 72. So every presiding officers, every commission has got the authority to prosecute any defaulter, even complainant, even if the complainant is not obeying the order of the district commission, he can be prosecuted by the district commission under section 72.
Only president is given the power, not the members.
I don't think so.
Yes,
There is no
No,
president
clarification it is given.
given.
Yes, only
By whom?
by government only.
National Commission.
No, government. By government, yes. Only presidents are empowered as to act as
Act as
judicial.
the act did not distinguish a president and a member.
That's right.
Actually, okay. If when the communication is received from the government, which government? The state government or central government?
Central government.
72, all districts are facing the problem. Any penalty comes, we have to follow the 200 CRPC. That is the trouble we are facing. See, immediately the JD are coming and saying that we have to follow this 200 CRPC. And 200 CRPC, it will take 1 year. That is the only
Actually, even the consumer complaint is to be tried summarily, and this complaint also, the disobedience of any order is also to be tried summarily. So it is for you because you know the entire facts. In the adversarial system, public prosecutor has to prove the guilt of the concerned person. As far as this case is concerned, you very well having the entire materials before you. Only one question, whether you comply to the order or not. If we say yes, so the evidence. If he did not comply, then the offense has been admitted.
There is a
So, actually, section 72 did not distinguish any president or member. Section 72.
but the power.
But power can be given by government of Andhra Pradesh.
Not now the president. Central government.
Whether we have received this from Tamil Nadu, any president has received such communication that only president has to what authorization or from Telangana.
Only institutions are referred, not president or member.
Presiding officer.
I draw the attention of this gathering. Whoever fails to complete any order.
Section 72. You are reading section 72.
Yes, exactly.
But powers is.
Yes.
Institutionally incorporated, not individuals, sir.
That is the discussion between me and sir. Actually, though there is no distinction in the section, government clarified in the position
Yes.
whether the government clarification have any overriding effect of the rule or act is a different question. But no such communication has been received by Tamil Nadu, Telangana and Pondicherry, I think. Pondicherry, Chandru. So, the next thing is slide. Next slide. Commercial purpose is here. Question of fact. Next slide. Lakshmi Engineering Works. This is the famous, and you can, whenever you deal with the commercial purpose, you have to rely only upon the Lakshmi Engineering Works. It deals what is commercial and what is not commercial, etc. It is the basic definition. Okay. Next slide. I am mentioning and to your knowledge 4 cases. Srikanth Mandri versus Punjab National Bank. Seema Engineering Service and the first case, Srikanth Mandri, the complainant got overdraft facility from the bank. And it is his allegation that the bank did not follow his instruction, though there is a deficiency in service. And the court held it is commercial nature. So don't entertain the complaint. He is not a consumer. The second one is Seema Engineering Services and Raj & Singh. The manufacture and sale of bricks was a question before the case. Whether manufacturing and sale of bricks by a family is a commercial in nature or for their livelihood is a question before the court. And the court remanded the case back to ascertain whether evidence are sufficiently let down by the provider, service provider. It is the duty of the service provider to elicit that the purpose behind availing the service is not for livelihood but for commercial purpose. So this is one of the second level of thinking. Third one. In this case, the trust filed a case stating we purchased a testing apparatus for their hospital and they are not conducting any business, there is no profit motive and other thing. So they have to be treated as consumer, but rejecting the claim, maybe you are a trust, you need not earn for livelihood or other thing, but it is a business. So the purpose for purchasing the machinery is business in nature, business to business. So you are not consumer. The fourth one is 4 friends joined together and started a photo lab, and they obtained some messages from the service provider in which it has been contended by the opposite party that it is for commercial purpose since 4 persons are involved and other thing, but the Supreme Court negated the contention. All the 4 persons are self-employed. They are running the business only to earn their livelihood and then it is not a commercial purpose. So you can get 5 different judgments. One is basic, which is a private or Quran or Gila, or deciding whether it is a case is for consumer purpose, commercial purpose or not. And the 4 cases differently explained the present evaluation of next Top Rate Source Limited Corporation. In this case, originally, return statement is to be filed within 30 days from date of receipt of summons, and the commission can power to extend another 15 days. So beyond 45 days, whether the commission had the power to receive statement or not is a question placed before the Supreme Court in Top Rate Source versus Corporation Bank, in which the Supreme Court held actually it is only a directory in nature, it is not mandatory, and the commission is empowered to receive beyond the period of 45 days and other thing. This is the judgment by the Supreme Court. I will tell. This above judgment has been followed in yet another judgment of Supreme Court in Kailash versus Kanpur. It is with regard to election case. The Supreme Court relied upon the earlier judgment mentioned there and held. So beyond the period fixed by the Act, written statement objection can be received, but it is not so. Even in the judgment of J.J. Merchant versus Siddharth Saturvedi, the period fixed for filing written statement is to be strictly adhered to. So subsequently, the matter has been referred to larger bench. New India Assurance Company Limited versus Delhi Multi-Purpose Storage. It closed the issue. Now we can receive the written statement beyond the period of 45 days. But the special mentioning is the summon must accompany with the complaint copy. Then only it is a valid summon, valid notice, and the time has to be reckoned from the date of receipt of summon. Next one. New India. So the same stop. It is the time. It is the time. So this is the evaluation because originally they interpret a law in one way and subsequently they modified, expanded, and later they have come to a different view. Now the prevailing situation is whatever be the interpretation which should favor only consider. Before starting with you, I want to thank the member because I am very surprised to know that with regard to a video circulated about the many judicial officers that a thought of honor was given to me was circulated. I was also astonished to know that thing because I retired in the June 2019 as a district judge. I am very fortunate. I had a very good team of judicial officers under my control, so that we improved the district administration in many ways. We have posted many, appointed many officers and staff of the court, and brought new courts to the district and everything. So whatever done is past is great. But the reciprocating Thanksgiving was memorable. She asked me, what is your impression, what is your role model? And in achieving those, I didn't have any role model, but I want to say one thing. My teacher was awarded Best Teacher Award by the Honorable President. At the time we congratulate him, I am only studying some 11th standard. At the time he told me, it is not a big issue, Karpaya. If I become a scavenger, I will get the President's Award for Best Scavenger. So whatever the job you held, whatever the position you held, you have to accept. It is my sincere dedication to the profession. Whatever I am doing, it brings to me here to address before you. Thanks for patiently. I am very Any questions? Any questions, please? I am really happy to say. Actually, I have come with a condition that I only ask questions. Nobody can. But the time வந்து 1 hour தான் பேச்சு வேடிக்கை பேச்சுக்கு இடமே இல்லாம வெரி ஷார்ட் ஃபிலிமா முடிஞ்சது.
Thank you, sir, for your elaborated talk on the students' thought on consumer law and the beautiful PPT that you have made in very different designs. So now I request Mrs. Priyanka Prasad, Assistant Professor, Dr. Ambedkar Government Law College, Puducherry, to facilitate our resource person, Kripalu sir.
Still, I am member of the WhatsApp group.
Thank you, sir. Thank you, madam. Now I invite Mr. Godwal Salim, member DCRC, Chittoor, Andhra Pradesh, to propose vote of thanks.
Good evening to everyone. Honorable President and members of 5 state commissions. I am very much delighted. Our sir's speech touching to heart to everybody. He has spoken from the Court area to company, Litigation Act, agriculture aspects, and also Consumer Protection Act is a social beneficiary registration. You find out what is the meaning of cavita empta. Cavita empta means ready by be aware. Cavita empta means ready some. Let the seller be aware. When buyer wants to purchase, he has to know all those things. When seller says, he communicate all information to the consumer. That aspect is. He also spoken about the limitation aspect also. Limitation. Our madam asked the question, what is the point, sir, we have to look into. The question is, we have to look our consciousness. Depend upon the facts and circumstances of the case. That is our commission also following, sir. Our commission following depend upon the facts of the case and also depend upon the what is the reason. Reason we have to first look into those aspects. Further going into various aspects that with regard to what is the limitation aspects in different ways, different cases, various Supreme Court decisions you have quoted, sir. Further, we also spoken about that mental profession and also bar association profession. So, company aspect also we have spoken. Whether company will come within the period of a person, in older act it will not come, but by virtue of 2018 act it will come. So, you have given number of Supreme Court judgments. We have enlightened as very well, sir. Thank you.